Good afternoon, everyone, and welcome to Companion Animals and the Law, Limits of Regulation, Session 1. The Center for Animal Law is hosting 4 sessions throughout the year that are going to be looking at companion animal issues particularly related to the city of Chicago. Our first one is on puppy lemon laws. We're also going to be looking at puppy mills, trap neuter release programs, and dog bite laws. Today we chose puppy mills. We have 3 speakers here, each with unique perspectives on the topic. We have Morrison-Ricordati of AMR Law Group. She practices civil litigation, business law, and animal law in Chicago. She is the past chair of the Illinois State Bar Association's Animal Law Section Council, chair of the Chicago Bar Association's Animal Law Committee, and the incoming vice chair of the DuPage County Bar Association's Animal Law Section. She has guest lectured at the John Marshall Law School in animal law and civil practice classes. Christine Rosso is Edwards Wildman Palmer in Chicago's office, a member of the Business Law Practice Group, where she primarily represents private equity, middle market, and publicly held companies in mergers and acquisitions and general corporate counsel. In 2013, she represented plaintiffs against Furry Babies Incorporated after the company sold them sick and mistreated puppies and presented fraudulent paperwork. She was selected for inclusion in Bardell Hubbell's Bar Register of Preeminent Women Lawyers in 2011. And we also have Representative Mike Zalewski, Illinois State Representative of the 23rd District. He is a graduate of John Marshall Law School, began his career at Cook County State Attorney's Office. He was first elected to state office in 2018, where he participated in votes including the impeachment of Governor Blagojevich, passage of the Capital Construction Program, and sweeping pension reform. He also sponsored legislation that cracked down on domestic battery and child safety. After his 2010 re-election, he became the House's chief sponsor for the Puppy Lemon Law bill. He also serves as chairman of the Elections and Campaign Reform Committee in the Illinois House. Once again, thank you all for coming.
So I guess that I'm starting. This is somewhat interactive, so please let us know if you have questions or comments while we're talking, but there will be Q&A at the end. So I, as you heard, am actually a transactional attorney, but I'm going to discuss a case that I'm doing pro bono with Lisa Simmons here, also at Edwards Wildman. She's been mentoring me through this process. And then because the case was filed before the puppy lemon law was implemented, I'm also going to give you a brief background on the puppy lemon law so you can kind of think through, how that law might have changed our case. And then finally, I'm going to very, very briefly touch on something that's not the focus of today's panel, but it's something that people involved in animal law, I think, should just know about. So I'm just going to flag it for you, which is Cook County's Companion Animal and Consumer Protection Ordinance, which is currently being challenged in court. A TRO was filed a week or 2 ago. So I'm very briefly just going to touch on that, and then if anyone's interested, I can send them those pleadings. So then Mike and Anna, I think, will go into more detail on the legislative process, the history of the legislation, and then the substance of the puppy lemon law. So just to start, a little background on the puppy lemon law. Like I said, it was implemented after we had filed our case. So it was implemented as of January 1st, 2014, so it's a new law. It basically requires 3 things that animal stores provide to consumers. First of all, it requires certain disclosures, I'll go into in a second. Then it tells you if certain things happen, what kind of relief you can seek under the puppy lemon law. So the types of disclosures are what you'd expect, how old the puppy is, what breed, what sex, that type of thing, the date and description of any inoculations or medical treatment, the name and address of the breeder, if the puppy is eligible for registration, the background on its parents, that type of thing. Interestingly, if the dog or cat has been returned by a consumer, then the date and the reason for the return. And then any sort of licensing the pet shop has, they have to disclose that. So these are the general, like I said, this is a big overview. Those are the general types of disclosures. And these disclosures must occur prior to the sale. So then, once that happens, once the puppy is sold, if certain things happen, you can seek relief under the puppy lemon law. Now these things are that if within 21 days or 3 weeks after the date of purchase, a licensed veterinarian states in writing that at the time of the sale, the dog or cat was unfit for purchase due to some sort of illness or disease, the presence of symptoms of some sort of contagious or infectious disease, or obvious signs of parasites that are extreme enough to influence the general health of the animal. So we're not talking like ticks and fleas here. We're talking something that impacts the health in an extreme way. Or if the dog or cat, unfortunately, has died from one of these diseases, then you can seek relief under the puppy lemon law. Furthermore, if within 1 year after the sale, the dog or cat, licensed veterinarian states, in writing the dog or cat possessed a congenital or hereditary defect that adversely affects its health, or requires hospitalization or non-voluntary surgery, or if the animal has unfortunately died of one of these diseases, you can also seek relief under the puppy lemon law. This is all if you have an agreed to different warranty to keep in mind. So the relief the customer is entitled to would be either returning the dog or cat for a full refund, exchanging the dog or cat for one of equal or lesser value, chosen by the customer, retaining the dog or cat and receiving certain reimbursement for reasonable veterinary costs, but not to exceed the purchase price of the dog or cat. If the dog or cat passes away, to be reimbursed the purchase price plus reasonable veterinary fees up to 2 times the cost of the dog or cat. So that's just a big overview of the law. So now and also I should actually say this, although it's less relevant to our case, but if there is some sort of outbreak of a very contagious disease, for example, parvo, then the pet store must disclose that to the Department of Agriculture, and then the Department of Agriculture can come in and basically quarantine. And if they decide to do that, then the pet store must notify people who purchase animals there within the last 2 weeks, I believe. So, yes.
Just for sake of clarification for those who might not be familiar with just the basics of the law, could you explain if the law applies to humane societies and shelters or just private businesses and why the law applies to those?
It just applies to private businesses. And that's just how they defined it. Thank you for that clarification. Okay. And we'll explain, Mike will explain why, since he actually drafted the law, so we'll get more in-depth into that briefly. Okay, so now I'm going to talk about the case. So I started at Edward Wildland about 2 years ago in the corporate department. So bear with me as I usually don't present in public. I'm not a litigator anymore. I only was for 2 years. The pro bono partner's office, and she said, you used to practice litigation. Do you have any interest in animal law? And I said, well, yes, I'm a lifelong animal lover, sure. And so Lisa, like I said, has mentored me throughout this, and she said, we recently were approached by a couple of animal rights organizations to represent some consumers. And so the Humane Society of the United States, the Animal Legal Defense Fund, and also the Puppy Mill Project. So they were the ones who initially got the complaints, and then they had to find someone to represent these consumers, and they came to us. And so that's initially how we ended up finding our plaintiffs. I should also add that the Humane Society and the Animal Legal Defense Fund are our co-counsel in this case. They're wonderful. We wish they could have been here, but they're actually not in Chicago. They're all over the country, all 3 of them, so they couldn't be here. But anyhow, so initially we started interviewing the plaintiffs, the potential plaintiffs, and we ended up with 7 people. But I'm only going to discuss 4 dogs, and these people happened to purchase dogs because there were several couples, so 3 couples, so that's why there are only 4. And the similarities are that all of these consumers purchased puppies from a chain of puppy stores called Furry Babies. And they all had issues with their dogs, which I will explain in more detail shortly. And they all signed the same warranty. And the warranty, briefly, it's that the consumers must bring their puppies to a certain vet. And that vet was selected by Furry Babies, and it wasn't always the same one. It was based on geography. And they had to take the dog to that vet for the first year. And they also had to bring the dog there within the first 4 days after purchase. Also, if there was something found during that first vet check, all reasonable treatment would be provided and a replacement would be paid for. And if they discovered debilitating health problems, they would be given a replacement pup. There was also a 10-day limited warranty for certain illnesses like parvo, distemper, hepatitis, and that there would be no charge for treatment. Now, I think the 10 days here comes from the incubation periods for these diseases, and that will become important a bit later. And there was also a 1-year warranty for life-altering congenital or hereditary disorders, and then the consumer would be entitled to store credit if their puppy came down with one of those. So that's generally what the warranty they all signed was, and that warranty is with Furry Babies Incorporated. There are also no refunds under that warranty, aside from what I just set forth. All the consumers heard the same representations, that these puppies were healthy, that they'd been screened for genetic defects and any health issues, that they were from reputable USDA licensed breeders. They even got a new puppy health card. So they all went in, they were all told these things orally in writing. So that's sort of how we ended up grouping them all together into one lawsuit. Now I'm just going to tell you about the actual puppies, what happened, and then I'm going to tell you a little bit about our complaint and where we are procedurally. So the first couple purchased a German Shepherd puppy. It was a Father's Day present. His name was Duke. And literally the next day, he came down with, he couldn't hold on food, he was vomiting. They rushed him to the vet, and he was diagnosed with parvo, which is highly contagious. Right, exactly, the next day. And the incubation period for parvo is essentially for 10 days. So clearly, they were sold a sick dog. So, unfortunately, Duke passed away within 2 weeks. And the Griggses went to Furry Babies and said, can you reimburse us the vet expense from the dog? And Furry Babies said, well, no, but we'll give you another dog, which is what the warranty provides. Now, parvo infects your home, and it can cause illness. Puppies are highly susceptible. Older dogs, less so because they built up immunities and had vaccinations, but puppies are highly susceptible for up to 2 years. So what kind of remedy is that? They can't bring a puppy into that because the puppy is likely going to contract parvo. So they never received a refund, either for the cost of Duke, which was, $1,600, $1,700, or for the vet expenses. Furthermore, later, because the papers weren't given to them in advance, they found out that Duke wasn't from a USDA licensed breeder, he's from an Ohio farm dog. And this farmer never even heard of the USDA, so it definitely wasn't licensed.
How did they find that out?
Actually, the pet store ended up providing the papers. But after the dog died, in this case.
In discovery?
No, they request them, they put them in the mail. They give them to them after the purchase, and I guess they figured people wouldn't follow up. Because they called, they traced the ownership back, and they called the guy, and he said, yeah, I'm just a farmer, I don't know what you're talking about. I sold them to some guy named Abe. And so, clearly, yeah, probably, right? He didn't want to keep the dogs. He had no idea what they were talking about. He's like, what's the USDA? So, so anyhow, that was that story. Very, very sad story, but yes, I guess there is some humor in, finding out where the dog came from. Then Denise Pizzell purchased her dog, Angel, a mini Schnauzer, and within hours, and now I should talk to Denise is actually in the animal industry. She run her own grooming business for a while. Within a day of being brought home, Angel was sick as well. She was having trouble breathing, and so immediately she rushed the Furry Babies to the vet, where she was diagnosed with a grade 3 heart murmur, hip dysplasia, and pneumonia. Furry Babies refused to pay for the x-ray, the vet paid for it, and then Denise paid for the nebulizer and other medicine that was needed. Not only that, but Angel's immune system permanently impaired. She suffered behavioral issues her whole life, and they refused to reimburse Denise for the vet bills. So Angel's lifespan is also shortened by all this, and she has trouble breathing to this day, even though Denise went to vet tech school to take better care of her dog and get cheaper medicine. This woman is very dedicated, and still, Angel has behavioral problems and is still very sick. And then the Ottos purchased Tommy a pug, and he was actually sneezing at the store, and they said, hey, what's going on? Why is the dog sneezing? And they were told he had allergies. And they said specifically, so he's healthy, and they said, of course, they said, oh yeah, of course he's healthy. Within days, he too was diagnosed with an upper respiratory infection, E. coli infection, staph infection, and a bunch of other infections I can't even pronounce. So yeah, he was also a very sick dog. He was in the vet on and off for months on end. He'd stay there for 2 months, in a row. And they also discovered that he came from a USDA licensed breeder with a lot of violations. So I don't think that would meet the definition of reputable. And Tommy is still alive, but once again, short in lifespan, constantly sick. And then the last dog was named Max. He's a Morkie. So picture this tiny little guy, and I've seen photos, really cute. In the store, they were feeding him some sort of gel. And once again, they, the store chief said, "What's that gel? Why are you feeding him?" They said, "Oh, he's just nervous. He's in a new environment. That's why." Well, unfortunately, Max was never able to eat, and he passed away very quickly from hypoglycemia. But the vet also said that she strongly suspected that he'd been taken from his mother well before 8 weeks. So he passed away. They did refund them the amount of money they paid for Max, but they refused to pay the vet bills because they really tried to save him. At one point, they even walked into the store and said, "You need to help us. We don't know how to save this dog." The next day, unfortunately, Max passed away. And also, I'm going to jump back. I forgot to mention one important thing. When Denise first realized how sick Angel was, she went to Furry Babies and said, "What are you going to do to help me?" And they offered her a replacement puppy. She said, "Well, what happens to Angel?" And they said, "We're going to put her down." So, I mean, what kind of remedy is that, right? I mean, they're basically saying, "We're going to kill the dog if you return her." So then, you really don't have a remedy unless you're okay with that. And obviously, Denise wasn't. So, they all came to us with these stories, obviously very sad stories, and we filed a complaint from LaSalle County. Our complaint alleges 5 causes of action, one of which is more prayer for relief. But, and I think you all actually were provided with a copy of our complaint, but if not, I'm happy to provide it. Just ask me after the talk. We allege Illinois consumer fraud, which we really like because it provides for trouble, damages, injunctive relief, and attorney's fees. So that helps us get out of, small claims court. A breach of contracts, written and oral. Breach of implied warranty, merchantability. Fraud, and then we pled injunctive relief. I'm going to discuss these a little more when I discuss the motion to dismiss that was filed, so just flagging what we alleged in our complaint. We also at one point did amend our complaint, particularly to strengthen the link between Furry Babies' actions and the damages, to make it clearer for causation arguments. And then also we were trying to link better the plaintiffs and defendants, and I'll explain why, but the defendant's structure is very unclear. You have them getting warranties from Furry Babies Incorporated. The stores are called Furry Babies Joliet, or wherever they're located, Stratford Square. So you have all these different Furry Babies entities. They share a website, but we didn't know who owned them. It wasn't clear from the Illinois Secretary of State website, and so we were trying to clarify which defendants actually said what to which plaintiffs. So we filed our amended complaint, and defendants actually then filed a motion to dismiss and a motion for sanctions. Right, they did file for sanctions, which we'll touch on briefly. We thought it was kind of egregious, but, and they pled a variety of things. So they pled improper joinder, which as we discussed, it was based on the fact that they claimed all the defendants weren't related. And we said, well, how can we know that? They have the same website, they're exchanging puppies, they have the same warranty. So the judge agreed with us that we are entitled to discovery to figure out who was doing what. One of the corporations was not in existence, and this is the crux of the motion for sanctions, but the store was existing and operating at the time of the sale, when the puppy was sold to one of our clients. So they argued that we had filed in bad faith, and we said, well, something was going on there, it had the same name. We did end up voluntarily dismissing that particular defendant in pending discovery. They argued improper venue, which was dismissed because obviously we picked where the defendants, the crux, most of the transactions occurred where the defendants were located. They claimed our breach of contract claim failed because we could only sue Furry Babies Incorporated because they were the ones who had the warranty. We said, well, hey, there's an oral contract here, all the representations you made, A. And B, you have all these receipts saying Furry Babies Joliet, so we don't really know who entered into a contract here. So, once again, that was upheld by the judge. They did focus on approximate causation, but the judge luckily agreed with us that we had established enough of a link. They claimed, it's kind of funny, they claimed that some of the statements were mere puffery, including healthy, the word healthy. And so the case, Lisa and I were laughing, we read it, it was about cereal. We're sitting here thinking, it's kind of, you can tell when a puppy's not healthy, right? So we don't really see how that's puffery. Luckily the judge agreed with us on that. They claimed, the typical things, we didn't plead enough particularity, but once again the judge agreed with us, at least for purposes of motion to dismiss. They also claimed, ironically, that the warranty disclosed what health issues could occur. Not quite sure what they meant by that, but kind of a weird argument. They claim we did not provide notice or reject acceptance. I don't know what plopping a sick puppy down in your store is, but we argued that was notice, and the judge agreed. They also claimed that we couldn't claim damages beyond the warranty. And we were able to defeat this in a variety of ways. First of all, we claim that the warranty failed in its essential purpose. Second, we claim you cannot contract around intentional torts. And third, the Consumer Fraud Act is an anti-waiver provision. So those are the ways we were able to sort of get, maintain that we could claim damages beyond the warranty, and we are indeed claiming damages beyond the warranty. Finally, they claimed that there was no, we couldn't plead injunctive relief because there's no future harm. And that goes to the Illinois Consumer Fraud Statute, which requires future harm for your specific plaintiff. And for us, there is some case law that discusses this, which I'm happy to send to anyone who's interested. But because they're requiring they take another puppy, there's clearly future harm for our specific plaintiff. That's the remedy they're offering. So we are able to maintain our action for an injunction, which normally would usually be the, something that AG, the Attorney General, would do. So we're very happy that we were able to show future harm for our specific plaintiffs. So that's where we are, and then we obviously defeated the motion for sanctions, which, as we said, we thought was somewhat egregious, and we were able to claim successor liability, promoter liability, de facto corporation, and the good old piercing the corporate veil. So that was obviously decided in our favor. And so now that's actually where we are in the case. We are, we started with discovery, and that's it. So that's all I can tell you now. We're very excited to hear see what happens. We're really excited to keep going. We love our plaintiffs. They're wonderful. And, they're not really in it for the money. What they're in it for is to change practices. And whether the puppy lemon law has done that or helps do that, that's my fellow panelists will discuss. We're happy to discuss in Q&A. But that was really the basis for the claims. That's really what they wanted to change. They basically all said, we don't want the same thing happening to someone else. We're really sad we lost these puppies. And, they think the puppies weren't given a chance. So another takeaway is that, the pet stores could have just let us, sue and then gotten a default judgment and said, hey, enforce this. And they didn't. They're fighting these cases. They're filing motions for sanctions. They're filing motions to dismiss. They're spending a lot of money on this. They feel under attack, and it's clear they're going to keep fighting. So until there's some sort of resolution, cases like this continue to be filed, I think we'll see them fighting. Finally, I also wanted to point out it's really hard for an individual to sue in a case like this. It's very expensive, litigation is very expensive, and the monetary damages are minimal. So you really almost have to sue through pro bono counsel. So, it is difficult for people to bring these suits. I just want to flag that. And now, so that's the case. Happy to talk more about it if anyone has any questions. Now, I'm very, very briefly going to flag something that's not exactly related to our panel discussion, but I want to flag because it's something that's really big in Illinois affecting animals, animal law. And that's the Companion Animal and Consumer Protection Ordinance. And very, very briefly, I'm just kind of flagging this. But I'm happy to send out the pleadings if anyone's interested. But what it is, it's an ordinance just for Cook County, unlike the puppy lemon law, which is statewide, that affects the sourcing of puppies. It says that pet stores can only source puppies, dogs, cats, and rabbits actually, obtained from certain governmental entities, humane society, or rescue organizations. Or breeders who are USDA Class A licensed, which means commercial breeders, with 5 or fewer breedable female dogs. So it very much limits how pet stores can source puppies. This particular ordinance is supposed to be implemented as of October 1st, 2014. However, defense counsel in our case and plaintiff counsel in this case has filed a TRO. So this law has been implementation has been stayed pending the resolution of litigation. But it's interesting, especially for those of you who like constitutional as well as animal law. It's being challenged on certain grounds: Commerce Clause, equal protection, federal law preemption, impairment of contracts, and that it's unconstitutionally vague. So it's just something to flag that you all should look out for if you're interested in this, and I can send you all the pleadings if anyone's interested. So, yes.
What is the federal law that they claim preempts the puppy, the lemon?
The Animal Welfare Act.
Yeah, Animal Welfare Act does have some regulations that cover internet puppy sales and things like that. It's basically stating that those places that sell the puppies over the internet, are subject to inspection, just like any other. But anybody who knows USDA inspections knows that they're not very thorough, and a lot of times any of the fines that come from that are minimal. So it's not very useful as a regulatory tool in this person's humble opinion. But also in August 15, 2014, USDA issued federal rule regulations about importing puppies overseas. So that could be what they're referencing. Basically, non-U.S. breeders have to provide certification for each dog that they're in good health, receive vaccines. And there is some stuff on the books about from the 2008 Farm Bill, which I don't think ever really got implemented because the USDA, even though there's a law there, they have to adopt the regulations that will actually implement the law. So it's a lot of ineffective laws that are currently on the books. And please, anyone in the audience, I know there's a lot of really esteemed scholars out there. Correct me if I'm wrong, but I think that's what they're they're referring to.
And they also claim the puppy lemon law. So this law that we just discussed also is one of the things they claim preempts.
One more question. You mentioned one of the dogs, you called it a farm dog in Ohio. What did you mean by farm dog? What's the significance of designating the dog like that?
What I meant was quite literally the dog was born on someone's farm. It was just his dog that he had on the farm, and it was born there. It wasn't any sort of term of art. It was literally just the description. And the issue was that it proved one of the misrepresentations. They were told the dog came from a reputable USDA licensed breeder.
Sounds like fraud to me.
Yeah, me too. So we're alleging, among other things, breach of contract.
I see you're suing this puppy shop, but how, if you win, how can you get the law changed? You're going after, right now, you're going after this puppy store, I guess, and then how does the law change after that?
Well,
Can I come in then?
yeah, go ahead.
So specifically, what we're trying to do is, first of all, we believe it raises awareness, which we think is important. And also, if we're able to get some sort of, if we beat them in court, then it'll set a precedent. And if not, if we decide maybe to settle, if they propose settlement, like a public settlement that sets forth things that are stricter even than the puppy lemon law. So that's how we're hoping to change practices.
And one of the things that was touched on, by counsel was that a lot of times the damages tend to be more nominal in nature. That's not entirely true. In Illinois, there is the case of Anslow, which I'm going to cover a little bit later. I'm going to let everybody go first, but we have some really good existing laws there, and it's part of the common law. So we have the legislative aspect, but we also have common law that sets up additional damages. So we would, or many of us would like it to be that the laws, the courts recognize that animals are worth far more to us than mere property, such as a table or a chair. Because, and I know I say this all the time, but I don't know anybody out there that would pay thousands and thousands of dollars to, fix one of these chairs. But if Tuxie, my cat, breaks his leg, I'm going to do whatever I have to pay for that. And that's something that it's inherent in animals and sentient beings, especially the companion animals. We're just now trying to get the courts to recognize, whether it be through legislation or whether it be through the courts, that these animals are in fact much more valuable to us, and that should be recognized in monetary values in court. And it's not, and again, it's true. Most of the people coming in are not looking for high dollar damages. They want recognition. They want something done. They want to be heard. But when you're dealing with businesses, the bottom line is the dollar amount, and that's why these damages are so important. And that's why the laws like consumer fraud, which does allow you the treble damages, which allows you attorney's fees, things like that, they're very, very important in bringing these suits.
So winning this case, then you would go with this case is like ammunition, and a bill would be drafted to the state senate or something.
Right, or we'd say common law precedent.
Common law precedent is much more powerful because every state can impose their own. Like one of the things that comes up with the federal laws, but each state can mandate higher standards of care. For commercially bred animals, some states have it, some states don't. It would be nice if we got something federally, in place and something better with the regulations. But I don't want to.
Mike's working on.
Yeah.
I guess that's a good
Question. You mentioned in paragraph 44 of the complaint, the family brought their dog to Fox Valley Veterinarian. Mm-hmm. Were any veterinarians listed as defendants in this case? And if
None
not,
were
why not?
listed. We do think once we have discovery and we get the actual veterinary names, we will be potentially calling them as witnesses. We have heard various stories from the plaintiffs about how the vets feel about their client furry babies. So we anticipate them coming in more as witnesses than as defendants.
So you purposely did not identify this vet in this particular complaint?
Well, we identified the vets only where we were establishing that they were in compliance with their warranty.
Okay.
If that makes sense, because the warranty required them to go to certain vets, and that's why we do identify them in the complaint. maybe further down the road, we do, as you'll note, we claim does 1 through 50. You know, we've left it open to sue other people, but right now we don't.
So there's no evidence at this point that there is collusion between the vets and who run these?
Evidence, no. We haven't got discovery yet.
Okay.
So suspicions, some of them yes, some of them no. Some of them honestly, you know, it's a lucrative contract and they entered into a contract and they were trying to uphold their end, but obviously in the complaint, you know, one of the vets ended up paying for the x-ray. So obviously some of the vets are very sympathetic to the plight of our claimants.
But you should know that the vets also under the Vet Practice Act do owe confidentiality to their clients. So if that pet store has a contract with them, they bring all these animals in and they say, oh, this animal's too sick, you know, we want you to euthanize, you know, animals 6 through 20. That's not something the vet is going to be able to broadcast, and it may actually pain them quite a bit. So it's the vet's in a very awkward position because they are required to do what they're asked, but you know, whether or not that's right or wrong, I guess that's something they have to make a decision about. And, you know, dosing them with medicines, you know, while that should be disclosed, if that's hidden, it's not the vet who has the responsibility of telling people. It's the pet store that has to tell them. Because, you know, we've also had cases, you know, predating this lemon law regarding people who, or one in particular, who purchased an animal from Happiness's Pet. And there were thousands of dollars in vet bills, you know, to bring that animal back to health. So it is a problem, and there are things that happen. In many cases, not just the Happiness and Pets or fur babies, but there are other stores selling them that may, you know, dose them so they don't have diarrhea when they go home, cover up the kennel cough, so that it all happens. And even though the vets are providing the treatment, they're not the people that are required to tell the consumer. It's the pet store.
And you should know during the negotiations, the veterinarians use the State Department of Agriculture as their sort of Trojan horse to make those very arguments. So what they would do is we would sit in a room and we would hear from the pet stores and the Department of Agriculture, and they brought in their top veterinarian. And they said a lot of the things that the advocates Humane Society want to do with respect to the 21-day rule, to the other rule, the other timeline rule, you're going to hurt a veterinarian's ability to practice medicine. Then we would go to veterinarians outside consultants and say, well, why do you believe that? And they say, no, absolutely not. So there's a lot of motive questioning in a lot of negotiations.
Yeah.
Yes, I have a question with respect to furry babies lawsuit. Have you, and I know you're early in it, you're just in discovery, but have you had to address the issue of what is a puppy mill yet? And the reason I ask this, and you may have, I have read the complaint before, but not for a while, so you may have very strategically gone around that specifically and having to deal with it. But one of the things with these pet stores is the consumers often, you know, now may even know to ask, you know, are these dogs from puppy mills? That's their concerns. They don't necessarily know what a puppy mill is. The pet store says, no, they're not from puppy mills. Well, I'm involved with the Puppy Mill Project, and this is an issue that we come up against with many of these ordinances in defining what is a puppy mill. So if the pet store in this case is saying, well, you know, a USDA licensed breeder isn't a puppy mill, you know, we can't be misrepresented. This isn't a misrepresentation. This isn't a puppy mill. It really hinges on how you define a puppy mill. And so I don't know if you've had to address that yet. And
We did.
Okay, and how did you?
We addressed it a little bit. First of all, we focused more on the link between the illnesses and substandard conditions and unsanitary conditions rather than the word puppy mill. However, I will tell you we found one definition, which is embarrassing. It's from a 1984 Minnesota case, and that definition is a dog breeding organization in which the health of the dogs is disregarded in order to maintain a low overhead and maximize profits. So when we were
relevant.
Sorry?
It's quite relevant.
It's just sad that the question hasn't come up more because this is a 1984 Minnesota case, and it's the only case we could find. And trust me, with our co-counsel, if there was something in Illinois, we would have found it.
It's the only one.
Right, exactly. So that's the definition we used in our complaint, but like I said, what we tried to do to get around that was focus more on the conditions rather than the definition of a puppy mill.
Lisa, what I was going to say is we actually just focused on the representations that were made to the purchasers, none of which involved the words puppy mill.
Okay, right.
So we didn't have to deal with that issue really head on. I don't even think we had much briefing.
Yeah, they brought it up briefly when they called, that was one of the terms they called puffery.
Yeah.
So that's how it came up. But aside from that, as Lisa said, we really tried to sort of not focus on that terminology.
Have you seen the definition of who may sell in the Cook County ordinance?
Pardon?
So have you seen the definition of who may sell? So I think the fair thing to say is whoever's not in that definition is a puppy.
Yeah.
And it's a weird way to define it, but that's probably the best way to describe what best practices are. And Kwiatkowski's bill does the same thing.
It's referring to the companion animal and consumer protection ordinance, just so you all know about.
Yeah, there's a bill that is pending in the state senate right now that would mirror the Cook County ordinance on a statewide level.
Wow, that'd be great. So what about the, oh, go ahead.
I was going to ask, since that you filed this almost a year ago, have you had additional prospective plaintiffs come forward?
You know, we have, and we have, some of them have come forward and decided, you know, we considered adding them, but then we had the issues when we were filing our amended complaint with making sure we linked each defendant and each plaintiff, so we focused on our current plaintiffs. And we have done our best to help the people who come to us. But at this point, we feel like our plaintiffs are so strong, we can't keep adding people. And so we've sort of given them help in other ways. They sent them to other people who can represent them, or you know, demand letters or something like that. Because we're far enough along that we feel adding other plaintiffs wouldn't help our case, and that since we agreed to represent these specific individuals, we really do have to focus on them. Having said that, you know, obviously we can amend later if there's a particularly compelling story that comes up.
I guess I'll go for a few minutes. And I want to get to the expert on the law. I drafted it, but I don't need an expert on it. That sounds accurate. I just would touch on a couple of points. And first of all, I'd touch on something Christina said. You mentioned WAP. You know, it touched on very briefly because it's kind of tangentially related why the pet stores would file an injunction to stop the ordinance. The reason is the pet stores are becoming an entrenched lobbying power, and they're doing it at the state level and they're doing it at the county level. Because quite frankly, I don't know a lot about pet store business model, but I gotta believe it's a profitable enterprise. I gotta believe that when people come in to want to buy a puppy, they usually can move a puppy out of the door pretty quickly. You got motivated people who wanna you can move a lot of products. So when we tried to pass the bill, I mentioned there was a lot of negotiations about the bill. And what happened was the pet stores did the smart thing, and they went out and they hired lobbyists, and they came in. And the bill got out of, what usually happens in Springfield is the bill gets out of one chamber. There's two chambers, the House and the Senate. And what advocates will often do is they'll pass a harsher version of one of the chambers, and they'll say, look, we're not negotiating at any points of this bill. We're going to pass a harsh bill. We're going to go full steam ahead, and we're going to see what happens. Because the only way to gain some leverage over the opposing side is to make sure that they have a reason to negotiate. So that's pretty much what happened in the Senate. Senator Dan Kwiatkowski passed a harsh bill, and frankly, no politician is ever going to be able to vote against a puppy limit law. You're voting against puppies and kids and consumer protection. Good luck with that. Even your hearts are never going to be able to vote against that kind of bill. So Senator Kwiatkowski sent over a bill that I think was on its face pretty good, but was a little flawed. I got an email from my general counsel. She's the chief counsel for the speaker and our parliamentarian. And her name's Heather, and she's great. And she emails me and says, Mike, I love your puppy limit law. It's a fantastic law. I love puppies, and I don't want to hurt consumers. There's just a couple of problems. It violates the UCC, and it goes fundamentally against contract law. Other than that, it's a great system. I said, Heather, what do I got to do? And actually, it wasn't a big deal because we just had to change some of the remedies portions of the bill, because her view was the remedies we were putting in the bill flew in the face of the UCC, and you couldn't really do that given that puppies were good, so to speak. You had to make sure that it lined up pretty good with the sales code. So we did that. And another sort of backstory on the bill was where the bill was sent for the speaker, what committee it was sent to. It was sent to the Agriculture Committee. Now, for those of you who don't know anything about Springfield, the Agriculture Committee is not a committee filled with North Shore liberal representatives.
That's a really gentle way to put it.
It's filled with downstate Democrats, downstate Republicans. And it probably was a very healthy thing for the bill. Because if you had sent it to Human Services or Consumer Protection, it would have flown out with no scrutiny, and you would have had people saying, of course I'm for puppies, of course I'm for consumers. Let's go ahead and let's pass this bill. But in agriculture, it actually got a very good, robust hearing. And the pet stores came out and they said, look, we can't live with some of the provisions of they brought in the Illinois Department of Agriculture, and they said the same thing. They said, look, veterinarians are going to be put in a very awkward spot here, and we understand the goal of the bill, and we want it to succeed, but we can't have veterinarians coming to us and telling us there's a problem with a bill passed from the General Assembly, because it's our job as the department to enforce the laws you pass. So we took a look, and we made some changes to the bill. We changed the amount of refund, I think, from 2 times the purchase price to 1 time the purchase price to conform with some concerns. We changed some of the other time periods to accommodate some of the concerns of the pet stores. And I think one thing that ultimately came about, and it's interesting hearing Christina's summary of her case because I didn't put this together, but it was actually a key provision. What we allowed the pet stores to do was say, you can substitute what's enumerated in the state statute for your own warranty. You can do that. But your own warranty had better be as good as a matter of fact, we were mandating that it be as good as what's in the state law, because otherwise you'd be in violation of the state law. It was frankly an accommodation to get the pet stores to agree to a bill. And looking back on Christina's lawsuit, I'm not sure we accomplished our goal, because it sounds like that they still feel like their warranties are going to be allowed to circumvent the process. So it looks like I have work to do. A couple other crazy, quirky things about the puppy lemon law, and then again, I'll get you guys get to the substance of it some more. But I joke about puppies and consumers and all that stuff, but in the time this bill was passed was a very awkward time for the General Assembly. We were dealing with conceal and carry. We were dealing with pensions. We were dealing with marriage. We were dealing with all of these unique issues for the state of Illinois, which in grand scheme, that's what we do. We have tough jobs and we have to make decisions, all that. But that was a particularly difficult time. And I got a lot of flack for carrying this bill. So people were like, what in the world are you carrying? Who cares about puppies and lemons? And what, I don't understand why we need this bill, and you're wasting everyone's time. And I'm sorry?
Oh, I was just laughing that you said who cares about puppies and lemons. It's like, this is funny.
Yeah, right. And so, some members openly mocked me on the House floor, like, this is what we're focused on when we got pensions to worry about. So, and it was disheartening, and you hear that, and you're just like, fine. But then people started emailing me. And it was the very victims that Christina was talking about. And they were like, don't let this be reduced to some political talking point. I took my kid into a pet store. My 5-year-old daughter bought a dog, took it home and watched it die in the next 10 days. And I didn't know what to do. And the pet store wasn't helping me out. And it broke my heart. And more importantly, it broke my kid's heart. And anything you can do as my state representative, or as a state representative from Carbondale, or Decatur, or Evanston, to fix that and to make sure that we don't ever see that happen again, you have my vote and you have my support, because that can never happen again. And it wasn't just one of these emails. It was about 6 or 7 or 8, which in the grand scheme of things is a powerful testimonial. And I would go, when we finally did the debate and we heard some more of this mocking, like, I can't believe you're doing this bill. I said, look, you can vote against this bill if you want. But this is a consumer protection bill. And it's our job down here to protect consumers. And we need to make sure that our laws reflect what we want a business to act like in Illinois. It's fine if you think we're putting too many burdens on businesses, and it's fine if you think we don't foster good job growth in Illinois. But ultimately, we need best practices in Illinois, and this is a Best Practices Act. And that was my pitch, and the bill passed. And it got sent over to the Senate, and it passed, and the governor signed it. Now I'm out of drafting here. There was a drafting here. The 2 times the purchase price, they didn't come out of the original bill, so we had to go back in the veto session. And that's just a reflection of telling you that sometimes there's scrivener's errors even in the legislature, and we have to be very careful about what we do because we don't like to do trailer bills in Springfield. We like to get things right the first time, despite what you hear on television. We like to get things right the first time. And then just finally, very quickly, again, touching on what I said at the beginning, this battle isn't going away. Senator Kotowski filed a bill to basically mirror the Cook County puppy ordinance. And I guarantee you the pet stores are staffing up right now in Springfield. They're going to hire good lobbyists, they're going to hire talented lobbyists, they're going to try to kill it. So to the extent you could be engaged and this issue matters to you, my guess is if you're here talking to me and the panel about puppy lemon law and animal law that you're really interested in this issue, let your state representative know. Let your state senator know that you'd really like them to see this bill passed because, quite frankly, we listen to our constituents more than anyone else, so your views are important.
Do the lobbyists you're referring to about pet stores, does this lobbying organization include more than pet stores, or is it just limited?
So Happiness is Pets hired a lobbyist themselves, and I don't know if they're big. Are they the biggest?
They're big enough. Yeah, they've got a lot. If you type their name into the Illinois Secretary of State site, you're going to see a list. They're very big.
Happiness is Pets hired their own person, and then I think there was a consortium of dog breeders who convinced us to take the dog breeders out of the bill, so it became pet stores only. I think Kotowski's version had breeders in it too, and we took them out as an accommodation.
I was surprised to learn that. I know some people in the movement nationally against puppy mills, and one of the opponents of doing something on a national basis is the American Kennel Association.
Or KC.
Yeah, big surprise.
Yeah, I think they have a lot of breeders. I mean, that would be
and I suspect that the reason you didn't get a lot of flack, also the livestock owners are huge. You probably didn't get that because you're not dealing with breeding, and that's what really concerns them. I mean, when you get to a real puppy mill law, which concerns breeding, that's when you're going to hear from Smithfield and all these livestock owners who are in the game, not because they have a dog in the fight, forget the pun, but because they're worried once you regulate dog breeding, next thing is livestock breeding.
And as weird as it sounds, you have I guess a social issue here with, you have, I won't lie to you, this was brought forth by the Humane Society, and not everyone's a big fan of the Humane Society. They equate them with PETA or other groups, and they think that they're just out to get the farmers of the world, and they're out to take someone's livelihood away. And like I said, you go into that committee, and you deal with those representatives who really have to advocate for their best interests of their constituents. You have to go up against that, and you have to answer some tough questions about what the real motives here are. But again, it was a testament to the fact that we got it out of that committee, that it was all is well that ended well. At least I think. Now I'm not so sure.
Just one more thing you got to change in this amending session, and that is section 8. If everybody, take a look at, 8.
To my Misselette.
When this got out of the House, it was going along really well. Things were chugging along really well, and then in the Senate, it went off the rails. Yeah, I'm sorry? I believe it's 51. So prior, if you look at 8.8, page 51, it says a copy of the pet shop. This is what they have to provide. So one of the things they have to provide, a pet shop. The pet shop's policy regarding warranties, refunds, and an explanation of the remedy under section F through M of this section, in addition to any other remedies available by law. What that used to read in the House was a copy of our policy regarding warranties, refunds, or returns is available upon request. Customers may be entitled to a remedy under sections F through L of this section, in addition to any other remedies available by law. Now, I'm going to explain why it's really important that this is not the only remedy available by law to people buying animals from a pet shop. But did you? I
want to hear it.
Okay. First off, I want to back up a little bit, and you may be wondering, because you guys are all now, it's like, well, it seems like there's a lot of public outcry about this. The animal welfare organizations, people are interested, they want this changed. Why is that not done? And it's exactly what Mike said. There are a lot of groups that have a very strong economic interest here. And I'm going to cite to you the American Pet Products Association numbers here, and these are U.S. pet industry figures and their outlook for 2014. This, any idea what kind of industry this is? You know, how much money the pet industry makes? Anybody have even a guess?
50 billion.
Yeah, close. 58 billion.
Wow.
58.51 billion is estimated for 2014. That is a huge amount of money. So the food amount, pet food, 22 billion. Pet supplies, over-the-counter medicines, 13 billion. Vet care, 15 billion. Now we know why the vets are very interested in this. Okay, live animal purchases, that's the lowest one, 2.19 billion. Okay, pet services, grooming, boarding, $4.73 billion. Now, you want to know, you know, the vets, most of us, you know, and myself included, always think highly of the vets. That's where we go. They advertise, AVME advertising, we're your other family vet. This is their policy statement. The AVMA recognizes and supports the legal concept of animals as property. However, AVMA also recognizes some animals have a value to their owners that may exceed the animal's market value. In determining the real monetary value of the animal, the AVMA believes the purchase price, age, and health of the animal, breeding status, pedigree, special training, and any particular utility the animal has to the owner should be considered. Well, that's not very much. You know, if you bring, you know, your dog's 8 years old, dies by somebody's wrongdoing, they're going to say, well, that dog's pretty old, not worth as much as what you paid. Maybe, you know, and some people, like, you know, me, would go to the shelter and adopt a dog, maybe $50. Well, you know, that's a problem with this definition, and, you know, and how the vets say that. But if you're a $15 billion industry, yeah, you have a financial stake in this. And what I find particularly hypocritical is that, just what I said before, you know, when I'm going to bring Tuxie in, I mean, it was $1,000 to get his teeth fixed. That's more than I've spent on my own teeth. That's
a lot more.
Yeah, so I mean, it's really, you know, it's a market, the whole market that bases its ability to thrive on your emotional connection to your animal. And if they're not willing to recognize the damages that will result if something happens to that animal, that is hypocritical and unfair. And while there are many arguments out there to be made for making sure, you know, their argument is always, oh, the expenses are going to balloon out of control, no one will be able to afford vet services. No, that's not true. You know, we're all, you know, all of us lawyers, we all have malpractice insurance. We all know, you know, you have your malpractice insurance. Sometimes it depends on what kind of cases you take, sometimes not. But, you know, we're all still able to go. You know, medical doctors are still able to practice, you know, when there's damages that are uncertain. So I don't think that's a real good argument, especially when if you look at these figures, and these are all available online, they have consistently increased. 1994, the total expenditures for the total U.S. pet industry was $17 billion. It's now $58 billion. This is a big increase, and it's only getting bigger. So just know those are the forces in place, and the particular industry definitions of all animals, they're all property. But we're in Illinois, so it's different here. So in Illinois, we have the case, when an animal is killed through negligence, and I'm not talking about intentional acts, those are totally different, more damages are available there automatically. But when you're talking about negligent acts, okay, you have two cases that are key. One is Anzalone. And I'm going to read you part of Anzalone because it is frequently misquoted. But in Anzalone, what happened is that a woman had her animal boarded at a pet store, or not pet store, I'm sorry, a veterinary facility, and her cat was accidentally let out, another dog was let out, dog killed her cat. So she sued for $100,000. And she brought that case, you know, here, you know, in Cook County, and the other side said, you know what, there's no way you're going to get that amount of money. Absolutely not. You get market value. This case doesn't belong here. But that isn't what happened. On appeal, the court said this. It appears the defendants object to plaintiff's lack of specificity in alleging Blackie's value to her. While at trial, the plaintiff bears the burden of proving evidence which affords some reasonable basis for ascertaining the value to the owner, so as to enable a trier of fact to exercise his or her judgment. We find no such requirement under Illinois law with respect to pleading damages. Granted, the amount of $100,000 claimed by plaintiff as damages is excessive under the existing precedent. Nevertheless, that is not a proper basis for dismissing the complaint. Until now, there has been only one purported case in this jurisdiction, Jankowski, back from the 80s, okay, purportedly discussing value to owner as a measure of damages in the loss of a pet. Consequently, it would be inappropriate to dismiss the complaint merely because the plaintiff's prayer for relief was deemed extravagant. So if you want to bring, if somebody hurts your animal, it's a negligent action. What that animal is worth to you is a measure of damages. And while you have to prove that as a plaintiff, that is the value. It is not market value here in Illinois, at least not here in First District, and I'll be happy to argue that one up on the appeal if it ever gets there. Also, Lee. One dog jumped into the neighbor's dog's yard, hurt the neighbor's dog really bad. Okay, they sued for damages for the vet bills to bring the injured dog back to health. In that court, the judge said, you know what, there's liability here. I see that. Okay, but we're only going to give you market value for the dog. No, that went up on appeal. The appellate court said, no, these people have proven what their animal is worth to them because they paid for these vet expenses. So you get at least the vet expenses. So that shows you that this is not the same, and that market value, just pure property is not the measure of damages here, and nor should it be, if you look at all of this. But my concern, with the puppy lemon law, and again, I think the idea was actually very, very good. We've had, I get calls all the time from people all over the state, and when they call me, they're sobbing because their animal died, and they don't know what they can do about it. And when you have to tell them, well, you get some damages and you don't get other damages, they are absolutely bewildered and saying, well, why? Why would that even, of course I'm connected to my animal. Of course I care. This is my companion, my best friend. All my kids are gone. This is my family. And when you tell them, well, the court's not going to recognize that. They're just, they consider property and you're going to get some damages, maybe not all. They are not happy to hear that. And they, and so of course I blame, I'm like, well, you got to go talk to the legislature. Maybe we won't be in the court.
Have them call the ad committee.
Yeah, and so you're going to have to do that, But that's what, happens, and that's why this is such an issue. And until it hits home, until it's actually your animal, it's not, you're going to think about the big issues, and you're going to think about, oh, what about vet bills and that? But when it's yours, and you're upset that somebody did something wrong, sometimes it's something completely stupid, like they forgot to turn the oxygen on, during a surgery. I mean, things like that. It's, something's going to happen where you want the full amount of damages and you're not going to get them until things are changing or until things move, whether it's through common law or through the legislature. But my problem with the puppy lemon law is, what we just showed you in section, in 8, because when you take a look at another portion, so if you want to take another look, and we talked about some of the things that you could do. It's M in this section. I forgot to note the page number here. I apologize for that. L-M. So if you go to M, and I think that's page 57 here. So if a customer offers, if a pet shop offers its own warranty on a pet, a customer may choose to waive the remedies provided under subsection F. So if this pet shop has its own warranty, just like was talked about by Christine and by Mike of the section, in favor of choosing a warranty provided by the pet shop, if a customer waives the rights provided by subsection F, the only remedies available to the customer are those provided by the pet shop's warranty. Now that's a problem if there are no other remedies.
But that goes to Christine. To me, if you're telling me that provision, that M being in there is problematic, and even after the effective date of the bill, then it means we have to go back down and take them out. At the time, though, the pet stores were effectively making the argument to pro-business conservative Republicans. We need that in there, or else you're going to kill our business model. And I know that's in a vacuum, that's a hard argument to make here, but in Springfield, in that environment, it's a very effective argument, and it would have probably, having M not in there would have been made it a difficult bill to pass.
In my argument, it would be then, it was probably, sometimes it makes it worse. Because here, we already had, and it's shown by the lawsuit, the previous lawsuit by Happiness is Pet, against Happiness is Pets, and this one for babies. There are already established laws in Illinois, like the consumer fraud bill provided for these damages. Because if you're dosing animals with drugs, you're putting them out there, and you're saying that they're healthy, consumer fraud. That's very clear. So, this law actually gives, in some interpretations, although I would argue, that because it was not intended to be the only remedy, that you can still bring consumer fraud, and I'm sure I'll have to make that argument at some point, but I would argue that you can still do that, especially concerning the disclosures, because this particular provision doesn't seem to cover all of what's required for the disclosure. So you could still do that if somebody's disclosing that, you know, this came from somewhere other than, you know, a farm dog, you know, then yeah, that's relevant too. It's just establishing your damages is hard. So here, by really restricting, you know, what somebody can go after is very hard, especially when there are other laws, there were other things in place that actually could have given them greater damages. And I say that only because, you know, again, the people are not looking for a windfall. They're not looking for great damages. But the only thing that will make a pet shop or make someone change their practice in a business model is the threat of high damages. If there is no threat of that, then what's the point? They're like, oh, it's like how they treat the USDA regulations now. Oh, I got a violation. Here's $200. You know.
So you believe in deterrent?
Absolutely. And I think that.
Girl.
But you know, but I think this law, you know, there are some unexpected positives to this as well. If someone was going to file a class action lawsuit, because these are all non-class action lawsuits, one of the big hurdles is establishing actual damages for each individual pet. So even if we couldn't change this, this is actually something that could be beneficial to class action lawyers, because then they can come in and not have to worry about that issue, but can make some change there. And when you get calls, you know, the 8 people involved in yours, I would bet there's probably 50. There's probably more. And so it would set up a class action pretty nicely. But I do think that somebody should be able to choose if they want to bring this under consumer fraud or if they want to bring it under this or both. You know, so that's really the only thing. And it actually, as it came out of the House, in Mike's defense, it did have that language in there. It just got derailed in the Senate.
No, I think you got it. I think I was the one who did the derailing.
Oh.
I mean, I go back to what I said. I think it came out of the Senate with M probably out, and I think in an effort to pass a bill, he made an accommodation. Now, I'm hearing what you're telling me today, and I'm hearing what's going on with the warranty that, my understanding is the warranty that was given to them in the lawsuit, right, is poor, and that means that the provision didn't work the way it was supposed to, which is a bad thing.
Well, let me just insert here, though, obviously our suit was filed prior to the
Right.
passage of the law.
Yeah.
But yeah, I think a lot of people are interpreting it that they can have their own warranty, and I don't think they necessarily realize it has to be up to these
Right.
standards.
My guess is the pet stores
Right.
haven't changed. My guess is the pet stores haven't changed their warranty all
Yeah,
that
probably
much.
not, yeah.
So that's what I think I'm headed.
I have a question from a more general strategic point of view. As far as, you know, the people in this room who really do want the best for all animals, companion animals, and I think if there's anybody in here from rescues, dog rescues, or humane societies, you're going to share in my concern here, that from a strategic, and this is an age-old welfare versus abolition debate, but in what ways could this law actually hurt all the dogs in shelters? Because you have a law now on the books that is making people more comfortable purchasing puppies from breeders, from pet stores, when, you know, they could just go to a rescue, they could go to a humane society and, you know, and adopt a dog who really needs a home for much less money. So my thought is maybe, and that, you know, as someone who tends to err more on the side of abolitionism and like, oh, we shouldn't have breeders at all, we shouldn't have puppy mills at all, I see this law and I'm like, oh great, you know, obviously it's meant to protect the welfare of animals, but it is going to perpetuate people purchasing from pet stores and that sort of thing.
I think you need to be a proponent of the city crime ordinance and the state law, or Senator Kotowski's new proposal, because those proposals really make animal shelters the only game in town.
Yeah.
I mean, for like.
I know, I'm thrilled with that ordinance.
I think that's your best course
Yeah.
of action.
And it's not preventing someone from going out and buying a dog at a facility. And actually, it kind of encourages people to go out and actually view where these dogs come from. You know, and maybe they would change their mind if they saw it. Because, I mean, I don't know how many people are familiar with the USDA regulations, but really, all a dog needs is, like, I think it's like 6 inches bigger than their body for the cage, and that's where they spend their whole life. I mean, so bad, you know, they talk about conditions being bad. You know, you see like this horror, some of the stories that are filmed, you know, Puppy Mill Project has a lot of filming on that. You know, or I know Carolyn might know more about like sort of requirements, but you'll see, you know, their little, you know, nails are like curled over into the cages. But yeah, but it's,
What can we do to stop this? What can you guys do?
Exactly.
That just ticks me off. I hear that
well,
stuff.
and that's why they're really, that's what they're doing. When they finally figured out to go after the economics of it, that's when, you know, as Mike says, they hired all the lobbyists and they put a huge force behind it, you know, to really stop, you know, those of us who want better conditions. Because for a long time, you know, and if you have to sell this stuff downstate, it's not so easy because you're facing these very people that run these industries, and when they're making billions of dollars off of it, they're not going to want you to come in and say, you know, we care about these animals. We're going to say, get out of here.
Yeah,
So
but the
you have
public's
to
on
take
your
the
side
economics.
big time, I think.
You know, I think if you look at the movements historically, you know, they're always met with this kind of resistance. As Maggie mentioned in a recent valuation talk, you know, way back when, you know, children were considered commodities. You know, it's not, you know, there are a lot of things that have, yeah, women, children, you know, these things, they have to change, and they're met with resistance because there always are economic interests involved. And so here, you know, when you're going after the economic interests, that's when things will change. But that's why, you know, the puppy mill legislation, I think the puppy lemon law was a good intention because a lot of people, you know, very good intention, you know, because people really were upset and they didn't know they could ask for more. You know, a lot of people just assume that the only thing you can get for negligence is market value, but that's not how it is here, not in Illinois. Texas, different story. But here,
Yeah, we don't want to be Texas.
No,
I'm just kidding. I unfortunately have to leave.
Oh, I'm sorry.
But you guys keep going. I
And
apologize.
once again, as Mike said, contact your
Yeah.
representative.
Yeah, please do.
I mean, show support.
Yeah, support the companion animals.
Have a bad.
So I think there's about 15 more minutes or so of questions. Oh, is it 1:30?
Yeah.
No,
Oh,
it goes
okay.
to 1:45.
Oh, okay.
So yeah, gone.
Yeah. Oh, yeah.
One thing I wanted to say along the point that was made over there is an argument being made by the pet stores against food companies and women's height is that consumers are better protected when they buy from a pet store because of the puppy lemon law and other, requirements that are in place as to the stores than they are when they go to a shelter or a dog. So they're using it kind of against.
They're using it to their advantage.
I see. I see.
I think that was the question that was asked before.
Right.
That's kind
I
of
mean,
what we're saying.
I think that an ordinance like the one Chicago recently passed isn't so much, it's not coming from a consumer protection standpoint, it's coming from an animal, rights standpoint, and the fact that.
Well, but we have argued a consumer protection basis for it, which is people are unknowingly buying these unhealthy sick pets, and they're not being, fully informed as to where they come from, they're kind of being misled. So there is a big consumer protection angle or basis for these ordinances.
I think she's referring to the companion animal and consumer.
Right.
Yeah. It's mostly because, like, even though, like, I think the vast majority of us in this room are on the same page. It's trying to sell that to the people that really don't, that don't care, that have the economic interest. And that's why it is a tough road, because it's either you make some step, or you make none and you wait for that tipping point to occur. But it's just that it's hard because every single day when the animals are in there, and they're suffering, you just think, what can I do? And it just because it becomes an internal struggle of, do I wait until it's, abolished, or do I try to get something better right now? And it's every person is different in their philosophy.
Right.
Yeah,
I don't know. I haven't figured it out either.
Yeah, but it's definitely tough. And
I think it's a multi-pronged approach. I mean, I think they're coming at it from so many different angles, and certainly making it less. There's a less economic opportunity for the pet stores. If they're paying double the fee or the
It's double the cost of the dog plus the refund of the dog. So ultimately, the way it's drafted, you could read 3 times the cost of the dog.
So, I mean, those things help to make it less economically attractive to be in the business.
And for a class action suit, that's bonus. Because that is the biggest or the hardest part of a class action is you have people with divergent values. Whereas here, if you file the class action, you have a very easy way of calculating damages. And the class actions are the ones that really do hit hard. So, I mean, I think that's a, again, unintended benefit, but it would be nice if this were, if we could just solidify their intention that this would not be only remedy available.
To switch gears completely, maybe, and on a lighter note, especially for Christine, I see that you're in front of Judge Holland, who I've never had the pleasure of being in front of. Granted, I've never actually tried anything in South County.
Nor have I.
Did you attempt to SOJ until you were in front of a known dog owner or lover?
He's a newer judge, and we sort of looked into him, and he seemed like, a little bit of an unknown, but he seemed like a good guy. There's some pictures he had a dog. So we did some research on him.
They say outside the house, looking to see if they can dog.
We were contacting people. We have a partner at the firm who's really connected to get some information on him. And, thus far we think he's a very fair judge. He gave us a well-reasoned opinion. And, we're hopeful. I mean, obviously we've survived more than some other suits that are pending have survived. There's one against Happiness's Pets. It's a class action, so different burdens, but we've survived a motion to dismiss and all our claims, so we're pretty happy with them, honestly.
And the judges here in front of it will make a big difference, but really, it's getting the judges to apply existing law to what they should apply it to. I mean, that's the weird thing is sometimes they'll think, oh, animal law, this is going to make me look weird. People aren't going to accept this, but really, it's just applying the existing law, like through consumer fraud. However you want to look at this, if you're going to treat these animals as products, then apply consumer product law. And guess what? You get the result you should get. But it's very strange sometimes the knee-jerk reaction you'll get. And again, I'm going to bet that's more downstate, more with some of the more seasoned or entrenched judges maybe that have either established this is the way I'm going to do things and that's it. But it's just very strange because it is refreshing when you get a judge that just applies the law as it should be applied. And it's like, wow, it actually works.
Yeah, there aren't that many judges in LaSalle County, also, I should say.
Oh.
It's far. It's kind of far.
You're in Ottawa, right? Ottawa?
Yeah, exactly. That's exactly where it is. It's about, we've
Been
been
there.
in the car 2 hours sometimes to get there. It takes a while, especially during rush hour, but it's worth it. It's with the proper venue, and that was upheld. So, yes. It is a cute courthouse. It's small.
It's a cute courthouse.
What else did you say?
Where Lincoln debated Douglas
I think I saw
150
plaques
years
about
ago.
that.
Yeah.
Yeah?
What the?
It's interesting. It's definitely, before when I was litigator very briefly, I was mostly in Cook County or, federal court, so it's different, but I think Judge Holland seems to just, he's on top of it. He clearly reads everything, and so, we're very happy with him. We lucked out, I guess.
But it'd be neat if you cover a little bit more about how some of the stores try to get out of these multiple suits because they have the locations when you look at, try to find out who the owners are. Because with Happiness's Pets, at least they all would boil down to Ron Vernon is the owner. But when you have another situation, maybe explain how that worked and how you tried or had to work around what you saw.
Well, I have to tell you, we're still in the process of discovery, so we're trying to figure out how they're related. But ultimately what we did is we, and I think I sort of touched on this, so we saw that there were Furry Baby stores, and there's a Furry Babies Incorporated. Furry Babies Incorporated is on the warranty, and the Furry Baby stores are where the dogs were sold. So we did our research on the Illinois Secretary of State website, and we're like, well, what incorporated entities are there? And then we sort of sued broadly because we looked, they all have the same website. They allow you to transfer dogs from one store to the other. So say you want a pug and there isn't a pug in Stratford Square, you can go to Joliet and get the pug, they'll transfer it. And Roger Trollinger, we do sort of have an individual we think is sort of the target person. He is named in the lawsuit. He's named as, the president of Furry Babies Incorporated. He is also involved with the other entities and claims he sources the dogs. So we've looked into other lawsuits that name him and stuff. So we're pretty convinced there's some sort of agreement. We're sort of thinking maybe it's some sort of undocumented franchise agreement. We're really not clear. So, but that's the way we've gotten around it is by stating there are all these similarities. There's clearly interaction. We need discovery to be able to figure out what they are, and we're happy that we want to sue the right people. We're obviously not just doing this for fun, suing everyone. So
but it's also kind of fun, though.
It is fun. It's something, it's fun to do this type of case. You're absolutely right. But we're not trying to sue the wrong people.
Well, they're all under the same trade name, and if they're, a trade brand, so if they're not contesting it, then, well, know?
Well, and they all have the same council too, which is interesting.
Yeah.
So we know they're connected. We have found out more about the ownership, and it isn't always Trollinger. He always is sourcing the puppies and stuff. So we're working on figuring that out a bit more, and I'll get back to you when we do, and we can say more about it.
It is, you know, it is important where the dogs are coming from too, because I mean, even like if you see the stealing dogs or any of the documentaries, like Levi Graber, you know, he's still out there. You know, there's people that have been cited multiple times by the USDA, which is, you know, not all that easy. You know, I mean, you have to do something pretty bad to actually get the fines and that. But I mean, yeah, I mean, and that's somebody, and this is, it comes up and it should just send up red flags to anybody like, whoa, you know, this is somebody who has been cited, and, you know, yet they're reissued these licenses. So there's a core issue, you know, problem with, you know, how this is regulated, how the licensing goes, all that stuff, you know, is a really big problem, you know, because if you consider somebody that's been fined multiple times a reputable breeder, that would be a stretch, you know. But then again, you know, if they're licensed again after doing all these horrible things, they're going to claim, well, I'm reputable because why would I have a license issued to me if I'm not reputable? You know, so you're in a weird place, you know, when you're dealing with the regulations and licensing.
I've heard the same thing about the American Kennel, whatever the name is, that pet stores say, we are approved by the American Kennel Society, and nobody knows what their approval is. They have no standards, nobody knows what the inspection is, but pet stores hold themselves out as, look, you can trust us, because...
It's all internal, yeah.
Exactly.
Oh, yeah.
What's the biggest vulnerability your plaintiffs have in these cases, do you think? What's the vulnerability your plaintiffs will have when they're put in front of a... I mean, what are you going to have to
Well,
face?
doesn't want to disclose.
Yeah. I'm trying to think how to say this. I mean, you know, I think it will be an issue who the defendants are. I think that'll continue to be an issue throughout discovery. We have to make sure we have the right parties involved. I mean, I think damages might be an issue as well. You know, and getting injunctive relief is going to be
What
hard.
kind of attack could the defendants make on the way those dogs were handled by the people when they're...
Right, yeah.
That's what I'm curious about.
Without going into your suit, they can claim that, oh, well, they got these diseases when you took them. Oh, you must have exposed them to your own dog who had parvo. You know, you'd have no other dogs, you know. You must have done something. You must have fed them poison.
Right.
Really? You know, crazy stuff like that can come up. They'll they'll accuse you of being the person who subjected the animal to disease somehow. You know, like, did you take this animal directly from the pet shop to your home that was sterilized? You know, stupid stuff.
You also claim that you didn't meet your obligations under any warranty. We saw that in our case, and that's, you know, clearly alleged in the pleadings that they claimed, oh, you didn't give us proper notice, you didn't do this, you didn't do that. And we're sitting there saying,
What
well,
about the length of time it's taken for these cases to go? Do any of your plaintiffs decide they really don't want to deal with this anymore?
you know, I mean, I think they'll each make an independent decision as to whether they want to go through, you know, the somewhat frankly invasive procedure that is litigation. You know, that's going to have to be their personal decisions. You know, and do I think they're fighters? Yes, they wouldn't have filed suit if they weren't. They feel very strongly about this, and you know, they've been great.
Most people in animal suits, you know, again, they're not motivated by the money aspect of it. They want their day in court. They want to be heard, and that's what motivates them. And you know, it's funny because like when you do business litigation, like call me when it's done. Let me know what the amount was. Okay, you know, but in animal cases, you really do have to let them know what's going on. You know, as far as like here's what they said. Here's what their arguments are. They're very actively involved in it, and that's kind of refreshing. You know, because you know they want to know what's going on, and they really do want to take part in it. But just to Alan's question about the AKC, that is an issue, and some. I won't say all, but there have been issues come up about pet stores claiming that they're AKC. You know, everybody comes from the AKC regulated, breeders. Again, no one knows really what that is. Some of them have been saying, instead of AKC, APR, which was American Pet Registry. So there was additional problems there, claiming they were AKC when it was really not. But the AKC is, the hard part is that there are a few of the I guess you call them responsible breeders, or the breeders that are the small scale breeders that maybe don't know what's happening on a bigger scale, or that these large puppy mills, the large-scale commercial breeding for profit, are in fact claiming AKC status. And although AKC has internal investigators that they may send out, none of us really know how that process works, or if it's working well or at all, or what kind of fines are imposed, if any. It's not, because I think it's a private organization, we're not really privy to those records. So I'm not even sure how we would find out.
I mean, I've heard registering, and this is not something I know as much about, but a lot of the dogs for baby sales are like, oh yeah, they're registered, and apparently all it is sending in a slip of paper and a very nominal fee. So then people think they're getting this great registration, and saying they could register my guinea pig as a dog. It just doesn't, you know, I mean, it's not really anything that's, you know, conclusive of anything. So.
But it goes on your wall, and according to the vets, it's part of your calculation of damages. So. That was, yeah. There's a couple minutes. Anybody have a question?
Yeah, we have time for a few more questions. Does anyone have anything else to add or ask?
Any legislation anybody wants to see? Because, you know.
What's the status of, I've never heard the ag-gag laws, ag-gag laws?
Yeah, those, they tend to crop up every year. And for anybody that doesn't know ag-gag laws, we do have experts in the room too that can talk about it, but it's where the industries don't want any filming of abuses that occur in their facilities. And that can, that can occur not just for farm animals, but it also goes out to the pet stores or any other kind of animal industry. So if you happen to see an act of abuse and you film it, and that goes public, and we've all seen that happen. And I think that happened to like McDonald's and some of the poultry providers. We see the conditions at their facility, and then consumers will revolt and say, I'm not going to buy anything from the store until you get your act together and start treating these animals better, at least within the regulations. But the ag-gag laws, as they're termed, tend to try to stop people from doing this. So they want it to be like the Animal Enterprise Terrorism Act, an act of much greater consequence if you happen to film this and then release it, whereas it would be covered with other, through other laws, trespass, publication, where they want special laws directed to protect their particular industry, which seems unfair. I do believe Illinois did not pass last year, but I know every year they are introduced. Every year it's a different angle. There's been more lobbyists hired, so we always have to be vigilant. Sometimes we don't catch these right away, because I was hoping Mike would have been here to explain this, but sometimes these bills are slipped in, and you don't have much time at all to react to them. So they may be on the floor for a vote before you even know that it's occurring. So that's why it's important that the animal organizations, HSUS, ALDF, ASPCA, all of them start putting money into getting the legislature, or getting lobbyists there to at least monitor what's going on and get the chance for consumers to say something.
I have two questions. First is related to that. Who would hire lobbyists on the animal side to try to counter agriculturists who want ag-gag?
The three entities you just listed.
Yeah, HSUS, ALDF, Mercy for Animals, anybody who's farm safe, right? Yeah, anybody.
Those
right.
Animal rights organizations.
Yeah, and then I was just wondering if you guys caught the name of the state legislator who is trying to get the companion animal consumer protection.
Zalewski. Okay. I know you had one question.
Oh, yeah, I was wondering if we could have, at minimum, yearly investigations of these puppy mills. Send in investigators to check them out. That would be legislation I'd like to see.
Well, they're actually already...
Yeah, that's supposed to be done. But the problem is that it's really not being done. And they claim a lack of resources, because like whether it's USDA or if it's Department of Ag, I think what are there, 5, 6 investigators that cover the entire state? 6 people at most. At most. I mean, there may be
102 counties.
For 102 counties, unknown numbers of not just farms that have to be inspected, large scale, but the puppy stores. I don't even know if they do shelters too or something.
So they do go into the puppy mills. These 6 investigators.
That's
do
it.
get
Yeah.
in?
Or and actually they're USDA regulated, so it'd be the USDA that has to send them out, and they have less resources. Well, maybe not.
Because I'm an independent investigator. Can I go in? Where are they?
Yeah, that's something.
Where are they?
They won't let humane investigators in. It has to be like the approved investigators. But
I was approved by Department of Ag. I'm approved by Department of Agriculture.
Oh, for the humane investigation.
Yeah.
Yeah, but it's still different because you're still.
Can I make one quick announcement because I'm concerned about time?
Okay.
On the topic of annual inspections, I just want to give everyone a quick update. I'm sure you all heard the news about the Dalton Animal Hospital this weekend.
Yeah.
So I'm an attorney. I'm assistant general counsel for Sheriff Dart, and we were the ones that were called out there. And what we realized is yesterday we were proposing legislation with the Chicago Bar Association's Animal Law Committee will be working on is that there really have not been inspections of these animal hospitals.
Right.
That there are great loopholes where the Illinois Department of Ag only inspects if they have a kennel license. The Illinois Department of Professional Regulation only licenses the vet and the vet techs, but not the facility. And so what the sheriff is proposing is that the county actually start doing inspections, just like this in Chicago. Chicago has an ordinance that says that the animal control has to inspect every animal-related business in Chicago, and the county should mirror that.
And they need some real fines that will actually make it worthwhile to do these inspections, because a lot, if they just don't have resources, they're going to have a way to fund it, and they're going to have to make it.
Well, we're actually in the drafting process, so the Bar Association of Animal Law Committee hopefully will be weighing in on that.
Good. It'd be great if they could do that statewide too.
There's no reason why they couldn't be, because when we're looking at the county, and every county under the Illinois Animal Control Act, every county administrator is supposed to be a vet. So there's no reason why we couldn't mirror that statewide.
Cool. Great. Yeah. So we have a new CBA animal law member right here.
Okay, any closing statements?
Thank you all for coming. Thank you for your time.
Before we started, I forgot to thank Margaret Livingston, the faculty director of the Center for Animal Law. Please give me your course evaluation sheets, and I can give you your CLE certificate. Thank you for coming, and we hope to see you at future events. Thank you.